Well, I do think in the interest of time and what we have to cover this morning, we can get started. Good morning, everybody. I know I see some familiar names in the participant list, but for those of you who don't know me, my name is Mark Adams. I'm Director of Compliance with the Employers Association of the Northeast, and I would like to welcome everyone to this much anticipated briefing that we are holding here this morning virtually on the Connecticut Paid Family Leave Law. During this 90-minute program, we will be covering this law and what we know as of today, though I would expect we will have other things in developments materialize after this event. And we will answer as many of your questions as possible. In light of the number of attendees at today's program, we will be asking you to hold off your questions until the end of today's program, in that we will address them at that latter point in time. However, we do invite you to type in your questions using the Q&A feature in the Zoom taskbar so we can review them and go over them at the end of today's program. With that, what I'd like to point out here is that I do mean that we are excited. I do mean the word we when we're talking about this event. We are excited to partner with the Connecticut firm of Carmody and Torrance, one of our longstanding law firm partners. And in particular, I would like to welcome two of the firm's partners here to co-present during today's session. First, I would like to welcome Vincent Faricello. Vincent, you can unmute yourself and say good morning to everybody.
Good morning, everybody. How are you?
I'm not going to go through all of the extensive background that Vincent has here. I am going to upload the slide deck into the chat for people for their future reference, so you will be able to refer to this at your leisure and pleasure. But Vincent's been one of our, been one of the active participants with our events and also at our Connecticut HR Roundtable that some of you might partake in. And I just wanted to thank Vincent for taking part here this morning. And then in addition, I would like to also welcome Nick Zano, again, another one of the partners at Carmody and Torrance and one of the co-practice leaders of the firm's business and personnel services group as well, for taking part here as well. So say good morning, Nick.
Good morning, everyone. Thanks, Mark.
Yeah. And again, here for me is, of course, my background as well. Which again, I'll be uploading the slide deck. So for any of you that were wondering that, I will be uploading the slide deck later on in the presentation, just because with respect to Zoom, if I upload it and people later log in, they won't be able to grab the link. So I just want to provide a fair amount of time and opportunity in case we get some late stragglers into the program here today. So here is this morning's agenda. I'm going to first turn it over to Vincent, who will tackle the big picture, if you will, of this law, as well as the timeline and administration of the program. And then from there, Nick will then take the baton and the reins and then step in to address the benefit, reasons, and notice requirements associated with this legislation. I will then step in thereafter to talk about the private plan option, some of the interplay and differences between the federal and Connecticut FMLA law, and then I will be wrapping up with some takeaways for you as employers and what you need to do now to be best positioned as possible to comply with the law when it is fully implemented come 2022. So we do have a rather ambitious timeline for this today. Again, we welcome your questions. We have endeavored to try to carve out time at the end to tackle those. So rest assured, we will be kind of bundling similarly structured questions in getting into this. The other thing, as we were talking about before today's program, is we know many companies are coming to the table here today at different sides of the spectrum with all of this. For some of you that might have been contending with FMLA compliance all along because you've been above 50 employees or 75 employees or much larger, certainly there are going to be changes that are going to disrupt what you've been accustomed to, both for you as HR and as well as your managers and supervisors. And that will be, we will be trying to address those considerations. But similarly on today's program, we understand there's going to be some smaller companies in the Zoom room here where this is all new territory from the beginning because they haven't dealt with some sort of legislative mandated time off program that's provided leaves of this type of duration. So we are really trying to cover in a way that really addresses the needs of both those audiences. And Nick, Vincent, and I will all try to kind of go through this material with that in mind. So with that, I'd like to turn it over to Vincent to get into the details of today's program. Vincent, take it away.
Thanks, Mark. And thanks, let me also say thanks to EANE for having Nick and me today. We always appreciate the opportunity to participate in EANE's programming. It's really top-notch stuff, so thanks. Mark, as you alluded, Connecticut's new paid FMLA leave is simply put one of the biggest legislative developments in the last 30 years and probably one of the largest that I can remember in my career. But what I'm seeing is that a lot of folks don't really appreciate the magnitude of it all. And this is especially the case, I think, with smaller employers, because there has been this misconception out there, right, that this is only going to impact the large employers. And as you said, Mark, that can't be further from the truth. And as the three of us go through the program today, I think everyone will see how this law will impact all employers. And I think it has the potential to radically transform the workplace. So if you go to the next slide, please. I want to dive right in and just get right into the big picture here. The legislation does three major things. One, it creates a state-administered FML insurance program. We'll refer to this throughout the morning as FMLI or the pay benefit. Basically, this will provide a wage replacement benefit administered by the state for covered workers who qualify for state of Connecticut FMLA leave. Number two, the law amends the state's current FMLA leave law. In other words, there will continue to be a job protection component under Connecticut's FMLA, but who is covered, what qualifies for protected leave, that will change under this law. And unlike the FMLI benefit, employers will still be responsible for administering the job protection component of this law. And the third thing that happens through this statute is that it maintains both of those two different benefits, the pay benefit on the one hand and the job protection benefit on the other hand. It maintains those separately and independent of each other, but on parallel tracks. So that's where we're going to see a lot of the complication here. But I think to understand the scope of the changes, a very brief overview of the current FMLA legal landscapes in order. And just remember, there are currently two different, but before we even get into paid FMLA, as of today, prior to passage of this law, there already has been two FMLA laws in effect, the federal FMLA law and Connecticut's FMLA law. Both essentially currently, as of today, are job protection statutes that allow unpaid job protected leave for covered absences. Can you go to the next slide, please? So let's start briefly with the Federal Family and Medical Leave Act. That does three major things. First, it provides eligible employees with unpaid leave from work for either the employee's own serious health condition or to care for certain family members with a serious health condition or for certain other family events. And the leave that it provides is up to 12 weeks during a 12-month period generally, or up to 26 weeks to care for covered military members or veterans with illnesses or injuries. And that leave under the federal FMLA can be taken in blocks of time, single blocks of time. It can be taken intermittently or even on a reduced schedule. The second thing the federal FMLA does, in addition to requiring leave, is it requires job restoration. So that means that employees must be restored to the same or an equivalent position at the end of their FMLA covered leave. And third, the federal FMLA provides some pretty stringent protections from retaliation and interference. That means it's illegal for covered employers to punish or discriminate against employees who use FMLA or to otherwise interfere with or discourage leave under the program. Next slide, please. So not all employers and employees are covered or eligible under the federal FMLA program. For employers, the statute only applies to those with 50 or more employees, and that's 50 or more employees for each working day during each of 20 or more work weeks, either in the current calendar year or the preceding calendar year. For employees, believe it or not, the first question is not whether their leave qualifies, but simply whether they're eligible in the first place. And to be an eligible employee under the federal FMLA, the employee must have been employed by that employer for at least 12 months, doesn't need to be consecutive. They must have worked at least 1,250 hours in the prior year, and that's hours worked, not hours paid. And they have to work at a work site with 50 or more employees within a 75-mile radius. And that's an important point for employers who have well in excess of 50 employees, but which are scattered in multiple sites. But the key here is to distinguish between employer coverage versus employee eligibility. In other words, it's definitely possible to be a covered employer currently, but to have employees who don't necessarily meet the eligibility criteria. And that's without even getting into whether the leave itself qualifies. But I think the final point here about federal FMLA, and this is a key one too, is that there is no undue hardship exception under the FMLA law. If an employee is eligible and their need for leave qualifies, the employer has no choice. The employer must provide the required leave, no matter how much of a headache that caused. And you contrast that with the concept of providing reasonable accommodations under disability law, where those are an employer only has to provide reasonable accommodations to the extent it doesn't cause an undue hardship. No such exception under the FMLA currently. Next slide, please. And so to complicate matters for Connecticut employers, Connecticut has had for many years its own Family and Medical Leave Act. This is before we even get into the paid component that just passed. Although the federal and the state statutes are similar, the fact is they're pretty different. Most times, if an employee is eligible under both statutes, the leaves under both can run concurrently. But because there's differences, there can be situations where an employee could possibly be entitled to two separate leaves under the two different laws. But let me just run through very briefly the key differences between current federal FMLA and current Connecticut FMLA. Currently, Connecticut's FMLA only applies to employers that have 75 or more employees within the state of Connecticut. And covered employees include those who have worked 1,000 hours in the 12 months prior to the leave, as opposed to 1,250 hours under the federal law. Also, the leave entitlement is a little different. Under Connecticut's FMLA, it's 16 weeks of leave over a 24-month period. And another key difference are the reasons for leave. Under Connecticut's current FMLA, there's additional reasons for leave that don't currently exist under the federal law. Next slide, please. So I gave you the kind of big picture of Connecticut's new paid FMLA law. Now let's drill down a little bit. As we do that, I would suggest note the underlined verbs here on this slide and see if you notice a pattern here. I'll get into each of these in more depth throughout the morning, but in broad strokes, the law expands who are covered employers, whereas you had to have 75 or 50 employees. That's now you only need to have one employee to be a covered employer. It expands who are covered employees. Employees will be eligible for job protected leave now after 12 weeks of employment, as opposed to 12 months of employment. It increases the amount of job protected leave available to covered employees from 16 weeks in a 24-month period to 12 weeks every year. It creates a new paid leave benefit. And the interesting thing here, that's the FMLI that I referred to. Employees could be eligible for that FMLI benefit on day one of employment. It creates a new payroll tax paid solely by covered employees. It expands the reasons that qualify for leave. Although Connecticut's law was already more expansive than the federal FMLA, it goes further than that, including who counts as family members. And Nick is going to get into that a little later. There's also, of course, new administrative burdens on employers, including collecting and remitting that new payroll tax to pay for the FMLI benefit, and imposing new and various notice requirements that Nick and Mark will get into in more depth. Next slide, please. The new law also limits the extent to which employers can require employees to use PTO during leave. It creates a new bureaucratic quasi-public state agency, the FMLI authority, which will administer the FMLI trust fund. The purpose there is to collect the taxes paid by employees and then to administer and pay out FMLI claims. And finally, the new law provides an alternative, although it provides an alternative to comply with the statute by offering your own private plan. Mark's going to get into that in some depth later on. And some of the feedback I've heard from many of our clients who've explored it is they found that it's not quite as attractive of an option as it might appear, but everyone will be the judge of that for themselves. Bottom line though, dealing with the FMLA, even before passage of this law, was already complicated enough. There's lots of regulations, lots of interplay between the federal and state law, and there's always been real opportunities for abuse and hardship. With these new changes, those problems will be compounded and multiplied, as now almost practically all employers will be required to comply. The leave will now be paid, and of course, the amounts and the reasons for the leave will be expanded. Next slide, please. So let's get into some specifics. I wanted to start with some key dates, some of which have already passed. First, employers who have one or more employee have already been required to register with the FMLI authority. Registration opened last November, and so all covered employers should be registered by now. If you are not, make a note to look into doing so as soon as you can. Since January 1 of this year, covered employers were supposed to begin withholding the FMLI tax from their employees' earnings and also remitting those withheld taxes to the authority on a quarterly basis. Now, quarter one just ended March 31st, so withheld taxes for Q1 are due now. There is a 30-day grace period, so payments for Q1 are due by April 30th, which I believe is this Friday. So if you haven't remitted those tax payments already, you only have a few more days to do so. To gear up for next year, later on this year in the fall and winter, the authority will begin to accept applications for FMLI benefits from workers. That way, as of January 1, 2022, the wage replacement benefits for approved applications will become available. So the FMLI benefit goes live online January 1, 2022, and in advance of that, the authority will begin collecting or accepting applications for review so that payments can begin as of January 1. The other thing that happens on January 1, 2022 are the amendments to the job protection benefits goes into effect. And we'll get into that in a little bit. But again, bottom line here, the rubber has already met the road. The program is underway. 2021 registration and withholding has begun. The trust fund has started to get filled, and starting next year, the benefits are available. So as I alluded, the definition of which employers are covered has been greatly expanded. For private employers, this will include any employer with at least one employee That's the same for both the FMLI piece of the law and also the FMLA job protection component. Again, that's a huge change. Whereas this only used to apply to large employers, now practically essentially all employers are covered. For public employers, they're only covered under this new law to the extent that they have what are referred to as quote unquote covered public employees. So for the state of Connecticut, they provide, they'll provide this benefit to any of their non-union employees. But for the rest of those employees employed by the state, or for any municipalities or local boards of ed, those employees will not be covered unless and until a labor union, one of their labor unions, negotiates participation into their labor contract, at which point any other non-union employees employed by that entity would then also be covered. The only employers not covered in any situation under the law are private elementary and secondary schools. Not sure exactly why that is. Could be a matter of just having had really good lobbyists. Next slide, please. So this slide shows who are covered employees, but this is for purposes of the FMLI benefit, the pay benefit. This is another huge change. Remember, under current FMLA law, to be eligible, employee must be employed for 1 year and have worked 1,000 hours. For FMLI purposes, all private employees are covered as long as they earned $2,325 from any one or more employees within 4 of the last 5 calendar quarters, and 2, they're either currently employed at the time they request they apply for the benefit, or they were employed at any time during the prior year, or if they're self-employed, they elect to participate in the program. The upshots of that is that a covered employee may be eligible for FMLI even if they're unemployed at the time. A covered employee may be eligible for FMLI on day 1 of employment. And also, those who are not employed, who work for themselves, are sole proprietors, they can choose to enroll in the program and be eligible for the pay benefit, as long as they commit to do so for 3 years. But think about that. A sole proprietor, self-employed person, is no one monitoring him or her. Kind of interesting. Next slide, please. So I'm going to regroup for a minute. We've seen that the FMLA has expanded to cover nearly all employers. We've also seen that which employees are eligible for the FMLI program, and that's pretty broad. But don't forget, like I had said early on, there's a split between the FMLI versus the job protection component, and the eligibility criteria for those 2 benefits are different. For purposes of the leave protection component, the employee must have been employed by the employer for at least 3 months preceding the request for leave. The consequence of that is that an employee theoretically may be out with FMLI pay, but the leave may not necessarily be protected yet. So the results can be chaotic and certainly susceptible to abuse, especially when folks don't even need to be employed at the time that they're they apply for or are eligible for the benefit. But I will say there are some anti-abuse provisions. And so if the state determines that someone has applied for, received benefits by making false statements or material misrepresentations, they could be debarred from participating in the program for a period of 2 years, or assess some penalties. So there are some anti-abuse provisions, but I think the bar for finding abuse will be pretty high. Next slide, please. So who's not a covered employee? Individuals who work for excluded employers. Like I said, that includes certain state and local employers. It includes private schools. It also includes the federal government. Employees of separate sovereign entities. So, that includes tribal nations. So Probably employees of the casinos are not covered. Individuals who work for sub-minimum wage, that certain minors for a period of time when they get hired, get to work for sub-minimum wage during that period of time, they're not covered. And also, there's a couple other unique situations, like one of the bullets says individuals not subject to state or local payroll taxes. Those are very unlikely to impact anyone on this call. Frankly, the FAQs refer specifically to the folks covered under the Railroad Unemployment Insurance Act or the Military Spouse Residency Relief Act. So very unique situations, not likely. Bottom line is most employees, almost all, will be covered. Next slide. So we know who's covered. Let's take a look at the benefits. Under the new rules, a covered employee could be eligible for up to 12 weeks of paid leave during any 12-month period. That's obviously available each year. Contrast that with the current law, like I said before, which is 16 weeks in a 24-month period. So now you could theoretically get up to 24 weeks in a, comparing apples to apples, you could get to 24 weeks in a 24-month period. And then aside from the regular 12 weeks, if the leave is due to incapacitation from pregnancy, an extra 2 weeks, so 14 weeks could be available. Just a quick possible, I don't know if loophole is the right word, but one thing that I was thinking about is as I was looking at this slide, remember again that disconnect between the FMLI and the FMLA job protection component. Recall that on day one, an employee could be eligible for FMLI, but not FMLA job protection for 3 months. Also remember that under the ADA, employer may be required to provide reasonable accommodations, which could include unpaid leave of absence. So reasonable accommodations generally should be provided unless there's an undue hardship, which we mentioned. So although an employee may not be eligible for job protected leave on day one of employment, even though they're eligible for the pay benefit on day one of employment, the job protection may still be there under something like the ADA, which, certainly the CHRO, the EEOC, or a judge or jury could certainly determine that some unpaid leave at the onset of employment is a reasonable accommodation. So how is the FMLI program funded? Like I said, by an employee paid payroll tax collected by employers, which will happen by auto deduction. The amount is currently 0.5% of wages up to the Social Security tax maximum, which is currently $132,900 of wages. So in other words, the tax is applied on the first $132,900 of wages. Who pays? All covered employees. There's currently no employer share in the program. It also applies only to covered employees who are engaged in service in Connecticut. So this means, for example, that if you had a Massachusetts resident who's working in Connecticut, they would pay into the program and be eligible for coverage. On the other hand, a Connecticut resident who's working in Massachusetts would likely not be paying in and may not have coverage under the law. Where do the funds go? Obviously, they go to the FMLI trust to pay for not just benefit payouts, but also administrative costs, advertising, and education and outreach. One question to think about, or that's been asked a lot of times, is can that amount, that 0.5% tax change? As the statute is currently written, it can certainly be decreased, but unless the statute is amended, it cannot be increased to more than 0.5% of wages. And if at some point the program started to become insolvent or didn't have enough funds to pay for benefits, the remedy without some other legislative fix would be that the authority has the power to reduce benefits, but not at this point to increase the tax. So as previously mentioned, the employer must remit collected taxes each quarter. Payments can be remitted either by the employer, him or herself, through a payment portal that's accessed at the ctpaidleave.org website. And we have, for your convenience here, the link to that website and the portal. Or if the employer is using a third-party administration service provider, that third party could remit the payments on the employer's behalf. In any event, it's interesting, the authority has decided that all payments must be processed electronically. They will not accept paper checks. So if you send a check by mail to the authority, that check will get sent back to you. There's a little bit of grace period for those employers who were unable to begin taking the deductions as of January 1, but only if that inability was the result of payroll system issues. If you were not able to do that because of problems with your payroll system and you were late in beginning deductions, then there is a catch-up option where for the first 2 quarters of 2021, you can deduct up to 1% of employees' pay so that you can catch up on taxes that are past due. If, however, the failure to begin deducting the taxes was for any other reason, then it's the employer's responsibility to pay for those delinquent contributions. Cannot get that from the employees. So we've talked a little bit about the authority. Thought very, very briefly give you a sense of who makes up the authority. Here, this slide shows the board of directors of the authority. You can tell here it's pretty political, a lot of political appointees. But in terms of who's actually running the day-to-day, a woman named Andrea Barton Reeves is the CEO. She's running the authority. Her prior experience was as a nonprofit executive. Her COO is a woman named Chris Floyd, who has prior experience as an insurance executive. And then also the general counsel is someone named Erin Chokwe, who's like I said, the GC there. And she has experience in state government working for DAS in policy and legislative advising. So how is the FMLI program administered? Well, there's going to be a lot of detail still to come, but the broad brush strokes is that to receive pay, a covered employee is going to have to notify the authority and their employer of the need for leave in a form that has not been provided yet by the authority. But then upon receipt of that application from the authority, the employee will have to provide certification on the need for leave. This is where, Nick's going to get into some of the process part of it, but this is one of those areas where we're still really waiting from the authority, for the authority to come up with procedures. This slide here, I'm not going to spend too much time on, but this is just more links for your benefit. Obviously, as an employer, you need to be registered. You also need to register to be able to file and remit the taxes that you've withheld. And so, depending on how you're doing that, whether you're doing it on your own or using a third party to do so, here are the different links to be able to do that. So, final point I'm going to make is, we know who the authority is. They certainly will administer the FMLI program and determine whether folks are eligible for compensation, but that does not mean that you employers out there who are used to administering FMLA can rip up and throw away your FMLA forms and your policy. You're still going to be responsible for administering the job protection portion of this leave. And so, one of the things that we're going to see and what we're still waiting on information about is how are these things going to work with each other? There's a question. If the authority approves a med cert for FMLI purposes, can the employer, as a practical matter, deny or question that leave for the job protection component of that? And it's on issues and questions like that that we expect regulations or some, some guidance from the authority. And we also are looking to see some of the specifics on how they're going to process the claims, how they expect us to process the job protection part of it, although some initial indications is, hey, you're responsible for the job protection leave. You do that as you've always done it. Nothing's going to change there. You leave the FMLI to us. We just don't know, how the sausage is going to get made behind the curtain there. So we're waiting for those regulations and looking forward to them. So with that, I'll turn the ball to Nick.
Great, thank you, Vince. And one question did come up, just picking up on that point about sort of rules are expected for the administration of FMLI. And we are awaiting regulations. And I saw that one individual asked a smart question, that says, does the statute actually say 3 months? And does it say 12 work weeks? And the short answer is yes, the statute does say 3 months. And I know it begs the question, well, what is 3 months? Is it 90 days? Is it 91 days? And it does use the term work week. So, that's where we hope that there are some regulations that will flush that out a little bit more for us so we can be more precise. But I'll just say that to Vincent's point about how this can become quite complicated when you layer on other laws like the ADA. It says in the statute that the Connecticut FMLA will be amended so that employees become eligible after 3 months of employment. So first question is, what is 3 months? Let's assume it's 90 days. But what if an employee comes to you at 75 days into employment and they've applied to the FMLI for a serious health condition that they have, or 60 days, let's say, of employment? The FMLI approves it and says, yes, your MedCert is approved. Here's your money for FMLI purposes. And then the employee goes to the employer and says, look, I need to be out. Can the employer simply say, well, it's been 60 days, you're not really eligible for FMLA until 90 days, therefore we're going to deny that leave. I'm sorry, we need to fill your position, out you go. And it's really not that simple. So even though the threshold number is 90, in reality, when you take into consideration other obligations that you might have under the ADA or even Connecticut disability discrimination, reasonable accommodation laws, the truth is it might kick in even before that. And so don't hang your hat too much on some of those technicalities like 90 days, or is it 89 days or 91 days? All these laws are related to each other and it gets pretty complicated. So with that, one of the questions is how much do employees get paid while in FMLA? And the slide sort of tells it all. But basically, when the FMLA kicks in, the FMLI kicks in on January 1, 2022, Connecticut's minimum wage will be $13 an hour. So the benefit for employees who are earning less than or equal to 40 times the Connecticut minimum wage, and 40 times the Connecticut's minimum wage is $27,040. And so any employee who is earning less than $27,040 will receive 95% of their pay. So almost full pay for sort of low wage earners. When the minimum wage kicks up to $15 an hour on June 1, 2023, that $27,000 threshold will increase to $31,200. So anybody once minimum wage is $15 an hour who is earning $31,200 will receive 95% of their pay. If an employee's wages exceed 40 times Connecticut's minimum wage, then their benefit rate will be 95% of the minimum wage multiplied by 40 plus 60% of the amount that their average weekly wage exceeds the Connecticut minimum wage multiplied by 40. So you add on the 60% number, and all of that is capped at 60 times the minimum wage. So when it gets a little complicated, you kind of need to actually run the numbers. But when the minimum wage is $13 an hour, the maximum payout will be $40,560. And when the minimum wage is $15 an hour, the maximum payout will be $46,800. So it's not an insignificant amount of money that an employee can get under the FMLI program. And so that is one of the concerns that employers have, is that FMLA, for those who are currently covered, employers who are currently covered, FMLA leaves can be difficult to administer. It can be difficult to get employees back to work. And sometimes the employees who are out in really critical positions. And as Vincent said, there is no undue hardship exception. You can't claim that it's a real hardship. And that's true, will be true for every employer, even if you have just one employee. And so employers currently grapple with that. And when you add the element of pay on top of that, there is real concern among employers as to, will we be able to get employees back to work? We really do need to fill some of these critical positions. And I expect that those questions will come up with greater frequency with smaller employers who have never had to deal with it, and who are just don't have sort of the numbers of employees to be able to fill in gaps when there are extended leave. So that's one of the challenges that makes this law, once it's implemented, potentially very challenging for employers. So next slide.
And just on the point of running the numbers, I believe there's also a calculator on the state website.
Oh, good.
For
Yes,
people,
there is, Mark.
in case you all are trying to model scenarios with your employees, which you probably want to do after this program, but because again, to Nick's point, it gets a little nuanced, but there is that online resource that'll give you some perspective of how it goes and how it's applied. Sorry about that.
Good point. No, that's good, Mark. So all this kind of has some employers scratching their heads saying, well, we've offered short-term disability. Should we make changes? Should we continue to offer short-term disability on top of the FMLI benefit that will be available for employees? And, the way you look at short-term disability is that it's both broader in some respects and it's narrower in some respects. So how is that? It's broader in that it generally pays 2/3 of an employee's pay for 26 weeks, whereas the Connecticut FMLA, if somebody's eligible for their own serious health condition, only pays for 12 weeks. It's narrower in that it only covers short-term disability policies and an employee's disability. It doesn't cover what FMLA covers, which is family members as well. And so most STD policies have an offset for statutory benefits that are payable. So, for example, if 2/3 of an employee's pay comes out to $600 and an employee will receive $400 from the FMLI for concurrent STD leave and FMLA leave, then the policy will only pay out the delta, the difference. So I would expect that short-term disability insurance premiums would be lower because the amount of benefits that will be paid out will be offset by the FMLI, because in most cases, if an individual is eligible for FMLA or FMLI benefits, they likely will be eligible for short-term disability benefits. Not always, but it's often the case. And so I would expect that policy premium should come down. And if you decide to keep STD and use that to sort of top off, the FMLI benefit up to 2/3, then you have to ask yourself, does that make it more difficult to get employees back to work? So there are just different considerations, and I don't know if Vincent has or Mark, but I haven't seen employers like in droves saying, okay, let's drop STD policies or no, we're definitely going to keep them. I think employers are just sort of looking at that on a case-by-case basis. Next slide. So the benefit, the FMLI pay will be available for intermittent leaves. So that intermittent leaves are probably the most difficult for employers to administer. Those are leaves that, for those of you who haven't dealt with FMLA, those are leaves that are taken in small pieces. So it might be a couple of hours a day, and it might just be sporadic. It may be with no notice. It may be somebody who has chronic migraines or chronic asthma. And that individual just needs time off whenever that chronic pain or that condition kicks up. And so, yes, they will be eligible for pay for those intermittent leaves, as well as leaves taken in a big block of time. And then there's a rule currently, which will continue to apply for spouses who are employed by the same employer. And essentially, the total number of weeks that spouses who are both employed by the same employer that they may take is 12 weeks whenever the leave is for the birth or son of a daughter, or placement of a child for adoption or foster care, or to care for a covered family member with a serious health condition. So both spouses in the aggregate can take 12 weeks in a 12-month period. But for purposes of pay, FMLI pay, each spouse will still independently be eligible for 12 weeks of pay in a 12-month period, regardless of the reason for leave. So there's a slight difference between how the FMLI benefits will be paid and the job protection part of the FMLA. And some of the benefits, I mean, the first bullet on the slide basically means covered employees may receive FMLA pay plus STD or sick time up to their full pay. So you don't have to. If your STD policy pays 2/3 and you want to continue to have an STD policy, then your STD policy will pay the difference between what they get in FMLI benefits and what they would get under the STD policy. If you want to require or employees elect to use their sick leave time, they can use that up to the full pay. So it can cover the difference between what they get in FMLI benefits up to their full pay. The second bullet simply means that when an employee is collecting FMLI dollars, they cannot also be receiving workers' compensation benefits or unemployment compensation benefits. So you can't double dip on the state provided benefits. It's either FMLI or workers' comp or FMLI or unemployment, but not both. As Vincent mentioned, there are expanded reasons as to why somebody can take FMLA leave. Now, this goes to the job protection part of the statute. And the big expansion really is the definition of what is considered a family member. And the family member now is expanded to include a sibling, a grandparent, and a grandchild. And so those are new classifications that will take effect on January 1, 2022. It also is expanded to include an individual related by blood or affinity whose close association the employee shows to be the equivalent of a family relationship. So that's the one that's gotten a lot of attention. Somebody who is like a family member to that particular employee can also be covered, even if they're not related by blood or marriage. And so it's somebody who is just very close to that employee, who the employee regards as a family member. And so, you know, the Department of Labor is supposed to issue regulations that sort of flesh that standard out a little bit, because there are understandably a lot of questions as to how the FMLI authority is going to make that determination. How is an employer going to make that determination of who's considered a close family member? And so we don't know yet without regulations, other than that's what the statute says on its face. And so again, it's these expanded classifications, including like a brother-in-law, you know, related by blood or marriage or adoption or foster care. What are the other qualifying reasons for leave? And so again, for those of you who are administering FMLA, hopefully this is already familiar to you. For those who will be doing it for the first time, employees will be eligible to take FMLA for the birth, adoption, or foster care of a child, to serve as a bone marrow or organ donor. Now that's not covered under the federal FMLA, but that is currently covered under Connecticut's FMLA and will continue to apply. For recovery during pregnancy or after childbirth, an individual may request 2 additional weeks of leave. So instead of it being 12 weeks in a 12-month period for pregnancy, and to recover from pregnancy, it's an additional 2 weeks for up to 14 weeks. Certainly for an employee's own serious health condition. Next slide, other reasons for leave. To care for a family member who has a serious health condition. Connecticut also has a statute that allows employees who are experiencing family violence to take 12 days of leave. And there's an entire statute that covers leave taken for family violence. But bear in mind that too is a reason for leave under the FMLI. To care for a family member injured during active duty, and for other reasons related when a family member is called to active duty. So those are the qualifying reasons why somebody can take family and medical leave. And so it is important, as Vincent had mentioned earlier, for everyone to understand that you still are responsible as employers, and will be as employers, for administering the job protection part. Like, that does not go away. You continue to have that obligation. Think of the FMLI as just an insurance company, because in essence, it functions that way. And so the employee needs to go to the FMLI to get payment, but you continue to administer the FMLA as you have been, and for new employers, you will be required to do that. So under current law, employers can require employees to substitute unpaid FMLA with any paid time off that they might have with certain conditions. The new law will limit the extent to which employers can do that. So employers can still require an employee to substitute paid time off for unpaid FMLA as long as the employee retains at least 2 weeks of such leave. So if you have a PTO policy and you want your employees to use PTO while they're on FMLA, and so in that case, the PTO would top off what they get under the insurance, right? So if they get a certain amount under the FMLI, you can require them to top that off up to their maximum rate of pay. But in no event can you require them to use more than, they have to be allowed to retain at least 2 weeks of that PTO leave. And there are pros and cons to that. You know, the pro is if you do require employees to sort of top off their FMLI benefit, they'll use up their PTO. And so it may limit the amount of leaves overall. The downside is if an employee is getting between what they get from the FMLI authority and what they get from PTO, if they're getting full pay, it may be very difficult to get that employee back to work because the employee is getting full pay. And so, you know, those are just various considerations that I think each employer will have to weigh for themselves. And, you know, it does require you to juggle a bunch of policies, and we've listed a few here, but honestly, you can add to these policies too. You know, you can add to policies involving pregnancy leave and pregnancy accommodation and workers' compensation leave and ADA policies that we've talked about. Each is separate. You know, each policy you have to administer kind of on its own, but with an eye toward the other policies because they all relate to each other. So if you have an attendance policy, you know, you can't just say, well, our attendance policy says that if you've missed, you know, 5 days of work over a 30-day period, you can be terminated. And so that's not true. If 5 of those days were for a covered or a job protected reason, like FMLA leave. And so again, for smaller employers who may not be familiar with the FMLA and sort of how that works, any time taken under the FMLA is job protected. So you can't use that as part of your attendance policy and, you know, enforcing your attendance rules. And so, you know, short-term disability, long-term disability, those are insurance programs. They don't provide any job protection. And they can run concurrent with FMLA leave. And so sometimes employers are under the mistaken belief that, well, it's STD, so it can't be FMLA. No, I mean, STD is insurance. It provides no job protection. But if the reason for that leave also constitutes leave under the Family and Medical Leave Act, they can and should run concurrently. And so, you know, this is where it goes beyond what we can cover today, but really when you get into the weeds of sort of administering these various policies and you layer on top of that the FMLA and the ADA and other statutory leaves, it can become quite complicated. The new law also provides some new notice requirements for employers. I think Vincent mentioned this early on. The statute says, and it's effective oddly, July 1, 2022. And I say oddly because the benefit kicks in, the law kicks in on January 1, 2022. But oddly, the effective date of the notice requirements are July 1, 2022. But when they do kick in, employers will be required at the time of hire and annually, and I find annually to be kind of peculiar, but annually provide written notice to each employee of the entitlement to FMLA leave and the reasons for the leave, the opportunity to receive compensation for the leave, that retaliation by an employer is prohibited, and that the employee has a right to file a complaint with the labor commissioner. And so the reason I say peculiar that you have to provide that notice annually is I'm not aware of any other law that requires an annual notice requirement like that. And, you know, will that be fulfilled by simply having a policy and a handbook? That is not clear yet. Again, that's something where we would hope that DOL regulations would flush that out a little bit. But read, this is what the statute says. Read literally, you know, this requirement would have to be done every single year. And so the process in a nutshell, and again, this is a very simplified version of the process for designating FMLA leave, is the employee's obligation is to tell the employer of the need for leave. And so that could be simply, I'm out today, I'm not feeling well. And then the employee continues to say that for an extended period of time. And the statute says that somebody can have a serious health condition if they're out for 4 consecutive days or after 4 consecutive days. And so if the employee continues to say, I'm out, not feeling well, I've got this condition, and then calls in again 2, 3, and 4 days, the employee has informed the company of the need for leave. Then it's the employer's obligation to determine whether or not that leave might constitute FMLA leave. And then the employer, if it might constitute FMLA leave, has to send out to the employee rather, certain information, has to designate that leave, can require the employee to provide a medical certification form. So the employee's obligation is to just say enough information to the employer for the employer to say, hey, that might be FMLA. Then it's up to the employer to designate that leave as FMLA leave. And if it could be FMLA leave and the employer fails to designate that leave, then the employee might still be protected under the FMLA law. So it's important for employers, when an employee is giving you enough information to put you on notice that, hey, it might be FMLA leave, for you to get those forms, and I'll talk in a minute about what those forms are, but to designate that leave as FMLA leave so you get that clock ticking. It's not up to the employee to say, I want to use FMLA, and it's not the employee's right to say, I don't want this to be FMLA. It is purely within the employer's right to designate the leave as FMLA leave if it constitutes FMLA leave, okay? The documents that you need currently, and I think that you'll continue to need going forward to effectively administer FMLA leave. Now these documents really come from the federal FMLA. And as Vincent said, the federal FMLA applies if you have 50 or more employees. And so if you have 50 or more, you'll continue to use these forms, and you'll need to revise them to take into consideration the changes to Connecticut's FMLA. But for those of you who have less than 50 going forward, it probably makes sense for you to get familiar with these forms as well, because I think you'll need to use these forms to administer your FMLA leaves as well. And that is just the employer requesting a leave of absence. What's your process for that? You would have to provide, once an employee puts you on notice, either because they specifically mention FMLA or they give you enough information for you to conclude, hey, it might be FMLA, you have to give the employee certain notice of rights and responsibilities that they have. You can ask the employee to provide a medical certification, and there are different types of medical certification forms depending on whether the employee has a serious health condition or a family member has a serious health condition. If they're taking leave for a qualifying exigency arising from being called to military service, there's a certification for that. And then you have to designate. There's a designation notice that says this qualifies as FMLA leave, or this does not qualify as FMLA leave, and here's why. You also should have an FMLA policy, and for those of you who have one, you'll need to change that to take into consideration Connecticut's new requirements. And then I'm certain there will be a Connecticut revised FMLA poster that you'll have to ensure is posted as well, along with the federal, if you're covered under the federal FMLA. So there are just certain documents that I think you need to have ready once this law takes effect so that you can properly administer these leaves. And then the last point I wanted to make before I turn it over to Mark is there are certain DOL enforcement penalties that they really apply for the FMLI program. So it really applies to employees who go to the authority and make certain significant misrepresentations to the authority in order to get benefits, or healthcare providers who do that. And essentially, if an individual, and I say individual because it could be an employee or it could be somebody who's not even employed, willfully makes a false statement or a material misrepresentation to the FMLI authority to get benefits. So the standard willfully makes a false statement or material misrepresentation in order to get benefits. They can be barred for 2 years from getting benefits. And if benefits are paid wrongfully, the authority can seek repayment. And if they were paid out due to a willful misrepresentation, the authority can seek a penalty in the amount of 50% of benefits paid due to the misrepresentation. So it's a high bar. I mean, it's willfully false statements or material misrepresentations. but at least there is a process for the authority to seek repayment and to provide a penalty for participants who make those misrepresentations. The law also provides a penalty for healthcare providers, and if benefits are paid as a result of a willful misrepresentation by a healthcare provider, again, may be difficult to prove, the authority can notify the Department of Labor, and the Department of Labor may seek a penalty against that healthcare provider in the amount of 300% of the benefits that were paid out based on that misrepresentation. So an even higher penalty for healthcare providers who who make willful misrepresentations on probably medical certification forms. So that's it. I'm going to turn it over to Mark, who's going to finish up by going over private plan and some other considerations for employers.
Thank you, Nick and Vince. And the one thing I'll just say, jumping into this, and first of all, I just want to kind of backtrack very quickly and look at our functionality. I can't upload the slides into the chat based on this version of Zoom. What we will do, though, is email all the attendees that after the program, just as a point of clarification, because I know probably some of you have been looking to some of this content extensively and the stuff I'll be covering. But, what's been mentioned off and on by both Vince and Nick, of course, is, this whole thing about, looking for regulations and guidance. And one of the things I would just simply say is, the authority's been chipping away at providing details over time. And one of the first aspects they provided details on was this idea of a private plan option. The Act did provide employers that they can opt out of the public program by virtue of going into a private plan option approach. While this is possible, it should be emphasized that a private plan being offered needs to provide employees with the same scope of benefits and wage replacement as that which would have been sought by a company's employees when they were seeking Connecticut paid benefits from the authority. So I also notice here some people are on the line who deal with also the Massachusetts paid leave, which also has its own private plan option. And I'm not going to do some comparison and contrast on that here in the interest of time. But I will say that the Connecticut approach does bring with it its own unique little options. But additionally, the scope of the plan cannot impose any additional requirements or conditions or burdens upon employees that they would need to undertake in order to submit a claim for benefits or gain approval on such a claim being filed. So from a cost point of view, the cost of what they could pay cannot exceed that which would be deducted from their paychecks had a company remained in the public track. So for companies looking to have their employees pay towards the premium for a private insurance benefit obtained by an employer, you need to bear that in mind. What is very unique for companies seeking to pursue a private plan in the state pursuant to the Connecticut paid family leave law is that there actually needs to be a vote that is conducted by that employer. Specifically, the plan needs to be approved by a majority of the employees, not just those who participated in the vote. That means considering your full-time employees, part-time employees, probationary employees, as well as those who might be out on existing leaves of absence, whether it might be an FMLA leave, a personal leave, workers' comp, STD, people out on vacation, or even full furlough. Anyone who is employed by the company who would have otherwise been eligible for Connecticut paid family leave benefits would be eligible for the vote, and a majority of them would need to approve the plan. During the process, an employer would need to provide employees with a copy of the policy, as well as what they call a plain language explanation of the plan and the voting instructions in order to allow them time to evaluate the alternative and then decide whether they indeed wanted to vote in favor of it. So the rules are not very explicit relative to the exact mechanics of the vote, and the authority has been very conscious of pointing that out. They really wanted it to be very flexible for employers as far as how they go about doing this. The only real components that they have really pointed out is that A, the vote does need to be an anonymous vote, and B, that it is limited to one simple question, and that is, do you approve the company's private plan to provide benefits required by the Connecticut Paid Family and Medical Leave Insurance Act? And that's, so it's a simple yes or no question to just that simple question. There's no, you can't tack on additional questions and get their impressions and, why they're doing it and why not. It's just a simple one question anonymous vote that is undertaken with your employees. It could be done electronically. So for those of you who have done other surveys through the likes of a SurveyMonkey or similar type of platform, you could do it that way. It could conceivably be done by a paper process, of course, if you can, of course, preserve the anonymity of that all. So for those of you who have had the wonderful experience of going through union organizing drives, you know what that might be all about. Regardless, it is important to retain this documentation of the vote and outcome should the state later wish to review or audit the legitimacy of that process. Now, there are a number of carriers that have already put together insurance products that have been filed with the authority and whose declarations are noted here. For companies that may still be contemplating going private and don't know where to begin, this list provides a good starting point to evaluate your options if you wanted to go fully insured. I will say that conceivably you can go self-insured as well. The one thing I will point out here is that there is a surety bond obligation for that that would be required to be posted with the authority, which would be the equivalent of 1 year's worth of contributions under that type of option. So to recap and to provide you with a step-by-step of the private plan approach, a company would first need to register their business with the Connecticut Paid Family Leave Authority, as been mentioned already this morning. And then you would need to, you could either provisionally seek approval through uploading a declaration of the insurance that you're intending to put into place. But ultimately what you're going to have to upload is the plain language that was provided to your employees, and ultimately the actual policy as well as the voting outcome in terms of the numbers, so that the state is fully aware that the majority of your employees have indeed endorsed that alternative approach. Once a private plan is approved, that doesn't mean that it cannot be revoked by the authority. Should the authority become aware of that plan not being administered properly or was obtained under false pretenses, that such as through coercion of employees, or should the plan fail to provide reports to the state as requested, or, are there situations where, they weren't administering or proving claims that they should have, that could all result in a revocation of a private plan and force the company to take part in a public option. Now, one of the open questions when we're talking about private versus public is we don't have any clear answers as far as, okay, an employee starts getting paid out on a benefit under the public plan and a company subsequently decides to go private. Does that claim still get paid out under the public plan? Does it go to the private plan? Or vice versa? A company maybe got initially a private plan option and a claim was paid out that way, and then they ended up going public. Does the private plan still continue to pay it out thereafter? So for those of you that might be having questions about the interplay in transition of claims with companies that go public to private or vice versa, those are details that we just don't have at the present time. And we would expect the authority, as they continue to progress through full implementation, hopefully we'll be addressing those considerations. So we've covered a lot of ground here this morning, but we also wanted to highlight some notable differences here that might particularly impact those companies that have to comply with both the federal and state Connecticut FMLA law. So again, for those of you on the line here who have 50 or more employees, this is of particular interest to you. I mean, unfortunately, the Connecticut and federal FMLA laws, as we've mentioned in various ways, are not identical. And that could conceivably mean that employees who end up being able to take time off under either one might conceivably, depending on the timing of multiple events, could end up taking more time off over a given year than either law contemplated. So for an employee who files, for instance, for Connecticut paid leave benefits and goes out for, let's say, an extended family member that Nick had talked about earlier, they might be protected under the Connecticut FMLA law and even be eligible for Connecticut paid leave benefits. But depending on that relationship, it may not count towards the employee's entitlement under federal FMLA. So should that employee later need to go out, let's say, for their own serious health condition, for instance, while conceivably they may not have options under the state law anymore if they tapped out that benefit, the federal FMLA could conceivably then kick in for that employee to be able to go out for additional time off with those protections. So again, and then similarly, when you're talking about reasons covered under the Connecticut law that might not be covered under the federal, such as for going out on leave due to being an organ donor, you could still have that type of same outcome as well. So again, we've all mentioned off and on here about, the idea of further guidance and regulations. I know the state's got FAQs that they continue to add, but there are regulations that are supposed to be forthcoming by the beginning of 2022 based upon the statute. I will say that amazingly, this is yet to happen. For those of you on the line who may have operations in Mass and have complied with the Mass paid family leave law and experience, you know far too well that there were 3 sets of regulations that were put out there before that law went into full implementation. Again, we're still waiting to, see when the state's going to come out with their own. Unfortunately, they haven't as of yet. So we wanted to kind of, transition into some takeaways and also some of the additional open questions that are still out there that we've touched upon already to some degree. Most notably, the exact interplay of STD and PTO during the leave covered under the new law, and how do the protections apply? Again, Vincent talked about some of those nuanced distinctions where the protections under the leave and the payment of benefits, might not necessarily overlap in lockstep with respect to that, so to speak. And, the other piece I would point out here too is, the whole aspect of the whole overall claims experience. While we know that, the claims process would be typically between the employee and the authority, or between the employee of an insurance carrier, for instance, in a fully insured plan, we don't fully know how the employer is going to be involved in the process in terms of providing supporting documentation, for the state to be able to fully evaluate a claim, or, even any sort of other step, even during an appeals process or anything like that. It's still kind of up in the air on this. As far as the question of pre-tax versus post-tax, we do know that the contributions into the system are post-tax. So basically, you are kind of looking at calculating that post-tax based on the dollar amount that you, of course, look at for doing your FICA. What we don't know and what remains an open issue is when benefits are conveyed to your employees, whether or not that is going to be taxable or not to them upon the receipt of that. So we do have some open questions there.
Hey, Mark, could I interrupt for 1 second? There was
sure, Vincent.
One really interesting thing. It's a little bit off topic, but it piqued my interest when you were talking about taxes here. With nearly all employers now covered under FMLA, or will be as of Jan 1, it's for the smaller employers, it's going to be a lot harder. You're going to have to, give someone leave and return them to their job when they come back. But for smaller employers, it's a lot harder to do that operationally. And so, you may not have enough other employees to cover that lag or to cover the lost output. And so lots of smaller employers will need to go tap into the temp market. And one of the FAQs I saw that was kind of interesting was, okay, we get it, that it may be difficult. You may have to put a temp employee in there while someone's out on job protected leave. But when you do need to return that employee if they come back within the requisite period of time, and then that temp employee, that temporary person might then be eligible for work unemployment benefits. And there's an FAQ that seemed to suggest to me that employers' experience ratings won't be impacted by unemployment claims from temp employees who lose their jobs after filling in for someone who was out on the covered FMLA. Did you see that too?
I did. I saw that, Vince. Yeah.
On some other open questions, I know we've had some questions in the chat about, using forms and, should we use the FMLA forms, at the 3-month mark for job protection, even though federal leave is at 1 year. And as Nick, I know, has alluded to, there is going to be a need to make some adjustments on those forms to fully comply with this state law, given that the service time is different, the reasons might be different. You might have to add some detail if you're going down the PTO use track based on the 2-week limitation. But, even to the broader open question, will the authority be promulgating their own model forms because, out of the means of being motivated by some consistent approach with the administration of things on the employer's end and what they might be seeking from an employer, depending on how a claim is ultimately adjudicated. All of that is still an open question there as well.
On that point, Mark, the DOL, the Department of Labor, put aside the authority for a minute, has never put out forms for the administration of the Connecticut FMLA. So even before this whole new law was passed, when we had Connecticut employers who were subject to both federal and Connecticut FMLA, we often took the federal forms and we just tweaked them. We modified them to include the Connecticut specific requirements. And so the DOL has had many years to provide their own model notices, and they haven't. And so I don't hold out much hope that they will now going forward. So I would encourage employers to become familiar with the forms now in effect. And you don't have to use the federal forms, but I find them to be helpful as guidance, but you just need to custom tailor them to cover the Connecticut FMLA specifics.
Yeah. But it is interesting, though, because of the rise of now this insurance benefit option, and to Vincent's point, too, of could someone who gets benefits and sustained by the authority automatically invoke the protections based on what the authority decides upon? Would there be any nuanced language that would have to be a part of the administration process? I mean, we don't know, but I would agree pragmatically with Nick's point of view is, and the other thing with federal FMLA, the Fed forms are model forms that a company doesn't even have to arguably use in and of themselves with the federal, but you've got to limit what you can collect to that which they put out as well. So, it provides a good starting point, but there would be some additional tweaks that would need to be involved. So what do you need to do now? I mean, we've talked about the registration process, obviously, in various ways, but you do need to take a hard look at some of your key policies. We talked about the juggling of policies that Nick had brought up earlier, but also, how agile is your business? How many roles can your employees step into to cover for others who might go out unexpectedly? I mean, do you have to think about things like job rotation systems to build up a wider skill base of your staff? Do you need to start flexing out or adding part-time or per diem staff to account for the rise of unforeseeable absences? I mean, different companies may attack this differently based on the nature of their operations, but those are going to be things you're going to need to really look at in collaboration with others on your leadership team. But in terms of doing a more specific dive on some key policies, I mean, when we're talking about your attendance policies, Clearly, you don't want to have language in there that is written in the way that would trample upon people's rights to go out under the Connecticut paid FL statute, whereby absences that are considered unexcused would cover situations that the law would protect. However, you may want to even take a harder look at clarifying your notice and call out procedures under these policies. The law sets a basic level for providing advance notice for foreseeable leaves, but how is that notice to be given of your employees to you? You know, you should really consider filling in any gaps if you want to be in the best position to be able to hold employees accountable under those provisions by showing you are treating your people consistent with others. So rather than not penalizing them for going out, you know, you might have some avenues, you know, as far as just not following your call out procedures themselves properly. But again, to do that means adding some more details. So what are the timelines for calling out? In what manner can they call out? Is it by phone? Is it by email? Is it by text? Do they need to personally contact HR, their supervisor? What if they don't get a hold of them? What's plan B? The more you can build that out in an objective way and be consistent with that, the better off you're going to be trying to be able to hold people accountable to that. And the better you can plan for that as well. I mean, when we're talking about your leaves of absence policies, you want to make sure those standards are adjusted. As been mentioned, people can be eligible to go out for leaves under this law conceivably from day of hire, depending upon, you know, their earnings prior to coming on board with you. And if you've got leave policies, you know, that are tailored to like a 12-month standard, for instance, you might have to tailor that down with respect to that. And again, you know, the Connecticut leave provisions themselves go down to a 12-week service requirement. So there's going to be some adjustments there. You know, there's going to be some adjustments needed regarding the expanded family relationships and covered reasons that we talked about as well. So for those of you that haven't looked at your leave of absence policies in quite some time, you know, those are going to have to be adjusted before the law goes fully online in 2022. You know, and then of course, there is the question of your paid time off policies, of course, and you know, what you want to do on it. I know Nick had talked about this briefly, you know, with respect to this, and that is there is this component that you can make people use their paid time off as long as you don't take them below a 2-week balance that they have. Do you want to do that or not? And if you do want to do that, you want to make sure both in your leave policy and in the PTO policy that you're consistent on that specific point so that those policies are in alignment and talk to one another properly. Certainly, you know, understand that if you choose not to go down that path, of course, you know, an employee can certainly elect to use their PTO, of course, as well, with respect to that. So for those of you on the line that are multi-state employers, that is a significant departure from the mass approach. So for companies that have, like, let's say a unified handbook and they're like, hey, can I have a singular paid family leave policy that covers both Massachusetts and Connecticut? You know, you may not be able to get overly explicit because some of these, you know, positions may not really be able to be harmonized exactly. I know Vincent and I have had conversations on that specific point, and that's going to be very hard for you to be able to do that. And then when you're talking about things like performance management and documentation practices, you need to evaluate those as well. I mean, when you're talking about holding people accountable for you know, while they're working, you know, are you being specific on where they're doing things right or wrong? And are you doing it now? I mean, one of the things to be mindful of here is it's going to be hard for you to start holding people accountable for not meeting performance standards or violating policies post 1/1/2022 on things that might have happened prior to that if you really don't have a paper trail or documentation that lays that groundwork that shows you're really kind of just extending off of that which has been in place all along. You know, to be able to all of a sudden hold people accountable for performance or violation of policy in the absence of a real paper trail, you know, post 1/1/22, when someone has been seeking rights under the Connecticut Paid Family Leave Law, is going to be a very big challenge when we're talking about them maybe then being able to say, oh, they're just holding me accountable because I've exercised my rights. And I think that's retaliatory as a result, you know, and again, we don't really know, we don't have much guidance on what anti-retaliation provisions really are going to mean in practice with this modified law. And then the final thing I wanted to talk about was, you know, I know many of you on the call this morning are human resource professionals or might wear that hat, you know, exclusively or in part. But the final thing is you really need to start talking to your supervisors and educating your supervisors about this law. You know, it's great to shore up your policies and fill in those gaps on those things we've talked about, but all it will take is a supervisor to act out in some negative or adverse way in how they communicate with an employee and who is going out to potentially undermine all of that other work that you have undertaken to put your organization in the best position possible. So for many companies, most notably very small companies on the line today, there will be the capability for employees to go out for longer periods of time than before, and perhaps for circumstances that you've never granted in the past. Your supervisors need to understand that. And for larger companies, there may be frustrations, of course, with the interplay of Connecticut Paid Family Leave and federal FMLA as well, and your supervisors need to understand that as well. So the bottom line here is that your managers need to understand the scope of what this law provides and its impact upon their role in supporting your business. So we ran through a lot this morning. We do have some questions, and I'm going to ask Nick and Vincent to unmute their mics, and we're going to go through some of these that we otherwise not covered. We've already talked about the 90 days. Is it 90 days or 12 weeks? I know Nick had handled that. At least we got a question of whether we can top off to make an employee whole. The answer to that question, I believe, is yes, that is an option. You just can't compulsory do it in a way that would take them below their 2-week balance and so to speak, but that can, you know, an employee can elect to do that on their own accord. Is there a minimum increment of time for intermittent leave? Nick, I know you had talked about the law itself. I believe in the existing regulations on the state, on the existing Connecticut FMLA law, it can be an hour or more. I don't know if that's changed with the adjustments here or not.
Yeah, I don't think they changed that, Mark, at all. I believe the federal law says it goes as low as your timekeeping system, your payroll system goes. So, but we'd have to double check that. To give you a firm answer, I would just want to double check. I know the law doesn't change the minimum increment. I'm just trying to figure out what it is under Connecticut and federal law. We'd have to double check that for the person who asked.
Okay. Does the medical leave after the birth of a child run concurrent with leave allowed for bonding, i.e. they would get 12 weeks of medical leave and then another 12 weeks of bonding leave? It's 12 weeks total.
Right.
Let's not give the Connecticut legislature any more ideas. We got another question on notice and the mention of notice annually. FMLA leave, what if I don't have enough employees for, I'm assuming he means federal FMLA leave, but I do have employees that qualified for paid leave. I only have 3 Connecticut employees. Do I have to send out this notice annually? Now, the question's silent as to whether or not they work in Connecticut versus residents. But if we assume we're talking about 3 employees that work in Connecticut, because that would invoke the statute, do you have to provide that annual notice to those 3 people?
Yes. So that individual who has 3 employees in Connecticut, 3 Connecticut employees, you are subject to the full Connecticut Family and Medical Leave Act, the job protection requirements. Your employees are entitled to get pay from the FMLI authority, and that notice annually requirement is a Connecticut law. So forget the federal FMLA. That is a Connecticut specific law that will apply to all employers who are covered under the, the one employer or more
Right.
rule in Connecticut.
Right.
Yeah. What's the definition of the 12-month period for providing the 12 weeks under this modified law?
That stays the same as it's been, which is the employer gets to choose whether it's done on a calendar year basis or a anniversary year basis or a rolling look back period or rolling look forward period. So that'll be the same as it was. The employer
And for those of you on the line who are mass companies as well, that's different from the mass PFML law. Got another question. This is on the self-insured option. Would that follow the private plan as far as majority of votes and cost limitations? The answer to that question is yes. The key additional distinction is the surety bond, but to be able to opt out of the public track, you've got to have a vote of those employees. And the other thing I didn't mention on that is the private plan has to apply to all your employees. It can't just be, we're going to go private with this group, but with the rest, they're public. It's got to be everybody, which for those of you who might be unionized, where you've got union and non-union people, that might be a challenge for you to be able to even do that. Is there a benefit waiting period?
I think this must mean, I believe this is probably referring to whether there can be a benefit waiting period if you're going to have a insured or self-insured plan instead of the state plan. And I would think that since that would not be allowed under the state system, you couldn't do that in your own private plan because that would be less favorable than what the state would otherwise allow.
But Vincent, what you're also mentioning is that the state in approving PFML benefits don't have a waiting period themselves. There's not like in the under the mass one, there's a 7-day elimination period. There isn't anything like that in the Connecticut.
No.
So again, that's a distinction too. Currently, there is an FMLA provision in Connecticut that allows an employee to use up to 80 hours of their own sick pay to care for a family member with a serious medical condition. What will happen to that provision?
I think I know what you're asking. That there's a law in Connecticut that says if an employee has sick leave, that sick leave can be used for up to 80 hours. That still applies. I mean, that would continue to apply to that employee. Again, you know, if it counts as FMLA, you can use that to top it off. You know, you can use their sick time to top off that FMLA if they're taking it for a family member. So that law remains in effect. It's an ability for an employee to use their sick time beyond their own personal illness, but for also family members.
Okay, we got another question here. If we covered this earlier, is it 12 weeks for all reasons or 12 weeks for each reason? It's 12 weeks total. Another question about, you sure about the bonding versus medical for birth? New York allows for both separate and mass might also. The Connecticut law, again, is just a combined total of 12 weeks for any combination of reasons.
Correct.
Okay.
Again, 12 weeks plus 2 weeks
For
there are complications related to the pregnancy. So up to 14 weeks in that scenario.
right. And that express 2 weeks addition is separate from the mass provisions too, for those multi-state employers here. How will the employer be notified of if and how much the employee is receiving from the Family Medical Leave Authority? All I can tell you is that they have gone on the record saying that there will be a communication of that agents of the authority with employers. They have not gotten into the mechanics of how that will take place as of yet. Another question, if an employee has less than 2 weeks of PTO, would they be unable to top off their benefits? An employer couldn't make it, but it could be elective on their part.
Sure. Yep. Correct.
I am planning to include this law in our handbook, and I'm working on an update now. Has the state issued any verbiage or documents that we need to or can use in the handbook? I guess you could say this is a question on notice. is there any sort of model notice for our handbook purposes that might be required?
I'm not aware of one. I mean, I think you should have an FMLA policy in your handbook. And, you know, the federal regulations provide guidance on what should be included if you're covered under the federal FMLA in that policy. I generally track that, even if an employer is not covered or going forward will not be covered under the Connecticut FMLA. So I would look to the federal FMLA for guidance, but on the specific question, no, the Connecticut DOL has not stated specifically what should be included in the policy. They did state what should be included in the annual notice, and that's on that slide. I put the bullet points in. That's taken directly from the statute, which Mark will send you the slide after the webinar is over.
Yes. Another question, we have been approved by the authority to go with the private plan. Would employees be able to begin to submit applications for paid leave in the fall winter timeframe? I mean, to me, whether they can submit to the public is going to be a byproduct of what period of time the insurance plan would cover. So if they've already been approved, and assuming that the private plan that has been approved has been for benefits that would be conferred around winter 2022 and beyond, there wouldn't be a need of submitting a claim to the state. Whether or not a carrier would open their window to submit the claim there, I'm not familiar with any details on that specific component. Do you two have any thoughts on that?
I think what this is somebody, it's November 15, and somebody has a planned time off for surgery on January 2nd. Can they submit the application on November 15th to the FMLI authority? And the FMLI authority has said yes.
Well, but this question was, they've been approved for a private plan.
No,
So
I'm with you, but with the idea that the private plan cannot diminish the rights that employees would have under the FMLI plan, I would think that the private plan, whether it's self-insured or through an insurance carrier, needs to
do the same thing.
Application in the same manner.
That's where
I don't know as a practical matter that a lot of employers have jumped to the private plan. I know there's one attendee who has, but I think it's a vast majority, in my experience, have stuck with the FMLI authority.
Okay, and our final question for this morning is, what part of the law says an employee still has to have 2 weeks of PTO in their bank? I missed that.
It's in the Connecticut. It's in the Connecticut FMLA as it's modified. I'm trying to find the specific section for you. It is in section, if you find the section 18 of Public Act 19-25. Section 18. You got to go down a little bit and you'll see that it says an employee has to be allowed to retain at least 2 weeks.
And there's also, if anyone who wants to go to ctpaidleave.org, there's some really good FAQs up. There's one that's directly on point under the category paid time off / vacation time.
Okay. A lot of good questions, a lot of good conversation. We're a little past the top of the hour, so I appreciate those who stayed on for a few extra minutes as we could navigate all these questions. This is still an ever-evolving topic. Certainly, I know Nick and Vincent, as well as the Employers Association, are going to continue to keep an eye on the authority, keep an eye on the Connecticut Department of Labor as more details unfold as the rest of this year progresses. So keep a watchful eye with us. We will certainly communicate and potentially put on other programs as details and news warrants. But I'd like to thank you all for taking part this morning. And again, a special thanks again to Nick and Vincent for working with us on today's event. Thank you, guys.